The topic is the termination of agency, which means putting an end to the legal relationship between the principal and agent. Section 201 to 210 of the Indian Contract Act 1872 lay down the provisions relating to the termination of agency. The termination of agency occurs. An agent's authority can be terminated at any time. If the trust between the agent and the principal has broken down, it is not reasonable to allow the principal to remain at risk in any transactions that the agent might conclude during a period of notice. Modes of termination can either be by the act of parties or by the operation of law. In the act of parties, the agency relationship is created by the agreement between the principal and the agent. Such a relation can also be brought to an end by mutual agreement between the parties, either in writing or orally. Termination by agreement may also occur if the agency relationship is terminated pursuant to the provisions of the agreement itself. The following situations may arise in this context. If the agreement provides for the appointment of the agent for a specified period of time, the agency will come to an end automatically when that period of time expires. If the agreement provides for the agency to terminate upon the occurrence of a specified event, the agency will come to an end upon the happening of the specified event. Revocation by the principal. The authority of an agent may be revoked at any time by the principal. However, unilateral revocation otherwise than in accordance with the provisions of the agency agreement may render the principal liable to the agent for the breach of an agency agreement. Any word or conduct of the principal inconsistent with the continued exercise of the authority by the agent may operate as a revocation of the agency. Revocations of the agent's power by the principal may not automatically discharge the principal from liability to a third party who is entitled to rely from apparent authority of the agent on grounds of representation by the principal of previous course of dealing with the agents before notice of revocation is given to the third party. Therefore, notice of revocation of an agent's power should be given to the third party as soon as possible. Renunciation by the agent. An agent is entitled to renounce his power by refusing to act or by notifying the principal that he will not act for the principal. Unilateral termination of the agency by the agent before he has fulfilled the obligation to the principal under the agency agreement will render the agent liable to the principal for the breach of the agency agreement, such as payment of damages for the loss suffered by the principal. By operation of law. Section 201, Termination of Agency. An agency is terminated by the principal revoking his authority or by the agent renouncing the business of the agency or by the business of the agency being completed or by either the principal or agent dying or becoming of unsound mind or by the principal being adjudicated insolvent under the provision of any act for the time being in force for the relief of insolvent debtors. Death and insanity. When either the principal or the agent dies, the agency relationship is automatically terminated. Insolvency of the principal. When the principal is declared as insolvent, the agency relationship is terminated. Expiry of time or fixed period. When the business of agency is completed, the relationship between the principal and the agent also comes to an end automatically. Similarly, where the agency has been created for a fixed time, the agency is automatically terminated on the expiry of that time. On destruction of subject matter. When the subject matter in respect of which agency was created has been destroyed, the agency is terminated. Dissolution of a company. When a company, whether it is of principal agents dissolved, the contract of agency between them comes to an end. Principal becoming an alien enemy. If the principal becomes an alien enemy, the contract of the agency comes to an end.